Hi, I'm Ben Holden, Director of the Reynolds National Center for the Courts and Media. You know, it may seem hard to believe in an era when Mel Gibson's voicemails and Britney Spears' choice of undergarments are regular features on the evening news, but the right to privacy is still very much a part of the American legal system. The possibility that a damaging piece of information might show up in a Google search years from now has in fact made people more protective of their reputations and more motivated to take legal action to protect them more than ever before. Our legislatures and our courts generally are protective of the right to publish newsworthy information, even when that information contains minor mistakes made in the heat of the chase. The great champion of the First Amendment, Justice William Brennan, said in the landmark case of New York Times versus Sullivan that because of our national profound commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, publishers must be given breathing space even for, and I quote, vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Now, we can never relax, however. We can never become lazy or complacent about defamation or defaming those we write about because the law demands that we act with reasonable care, and furthermore, our own journalistic ethics demand that we verify what we can and level with our audience about what we can't. Technology now enables us to publish from a pocket-sized device at our dinner table. And make no mistake about it, tweeting is publishing. But the ease of online publishing should never make us casual about the truth. Truthfulness is still the best insurance against the claim of defamation. And a commitment to the truth above all else, not just the size of a paycheck, is what makes a journalist a professional. Here to tell us more about the laws of defamation and the right to privacy is Frank LoMonte, Director of the Student Press Law Center.
When you're a journalist, and you are, and you're talking to a lawyer, and you are, one of the first things you want to know is, what can I get sued for? And the flippant answer is, of course, anybody with 25 cents and a copy machine can sue anybody for anything, right? The question is, what can I do to reduce my chances of actually losing a lawsuit in the unlikely event that as a student journalist, I'm actually the target of one? We're going to talk about the two types of claims that would be the most likely claim that an angry person might bring against you or your student media outlet: libel or defamation and invasion of privacy. The first thing you need to know about defamation is that it's harder to defame people than a lot of people think it is. You'll get that angry phone call, you'll get that angry email from somebody who says, "You defamed me," and what they really mean is, "You made me look bad." Well, sometimes as a journalist, that's your job. If the person has done something bad, then it's not defamatory to truthfully and accurately report on it. Defamation is concerned about the publication of false factual allegations. So let's start by talking about the 3 F words of defamation, because if you don't learn these, you'll be saying some other F words. The 3 F words of defamation are false, fact, and fault. False, fact, and fault. And let's talk about the first 2 of those together because they go hand in hand. Defamation law is concerned about factual statements and not pure statements of opinion. If your column says, "Coach Jackson screwed up the game, he's a terrible coach, never should have got the job, athletic director should fire him," all those are fine. All those are pure statements of opinion. Coach Jackson's never going to be able to prove he's not terrible, right? That's not a provable fact. Where you get into a danger zone is if you embed within that statement of opinion a fact that can be proven true or false. So if your column says, "Coach Jackson should be fired because he bought a fake college degree on eBay," and Coach Jackson can show he didn't do that, now we have a potentially defamatory statement. That information has to be not just a little bit wrong, but substantially false, okay? If the sting of it is right, then it doesn't matter for libel purposes that you got a detail wrong. So if you publish a story that says that a university employee was pulled over with 40 marijuana plants in his car, and it turns out that he really only had 30 plants in his car, right? He's not going to be able to show that those 10 plants were the decisive difference. He's not going to be able to show, well, I lost my job because they thought I had 40 plants, but I'd still have it if I only had 30, right? He's not going to be able to show that that mistake was a decisive mistake in any damage or any harm to him. That's the doctrine called substantial truth. Your reporting was substantially true, okay? Ethically, you want to correct it, of course, it's a mistake, but legally, it doesn't make a difference for the exposure to a claim of defamation. Anybody have any questions? Yeah, go ahead.
So if I write something and I preface it with, in my opinion, but then it ends up on the front page of the newspaper and it's clearly in the editorial section so people know it's opinion, am I protected?
That helps. Anything that gives the audience a contextual clue that what you're talking about is opinion, not fact, may help you in a defamation claim, but it's not decisive. The Supreme Court actually decided a very famous case called the Milkovich case. And the Milkovich case involved an opinion column. It involved a sports opinion column, where a sports writer wrote about a wrestling meet that he had attended and a subsequent investigation into the conduct of the coaches. And what he said in his opinion column was, having seen the wrestling match, I know that the coach lied under oath in the investigation. And again, he embedded a statement of fact in the context of opinion, and the Supreme Court said that doesn't prevent a claim of libel, because it's all about how the reasonable reader would receive that information. And the reasonable reader thinks that that columnist is saying, I have inside knowledge, I know this to be a lie because I saw it with my own eyes. So the in my opinion preface doesn't immunize you. That brings us to a very important tip. One of the dangerous practices that we will sometimes see from time to time is that people get a little sloppy with their facts when they're writing in an opinion context. So that, let's say the news side of your newspaper writes a story about a police officer who's suspended on a charge of police brutality. And then the editorial writer comes in behind that story and says, how dare these dirty, corrupt cops try to get away with beating up innocent people? Well, of course, the cop hasn't been convicted of anything yet. And if he's exonerated and if he's cleared, then that editorial could be defamatory. So you don't want to let the context of an opinion piece make you sloppy or casual about the facts. That takes care of the first two F words, false and fact. Now let's talk about fault. Fault means that it can't just be an innocent slip-up. Stuff happens. Mistakes get made. You get a headline garbled. You drop a word out of the story as a typo. Everybody understands that. The law makes some allowances for that occasional innocent mistake. A person bringing a defamation suit is going to have to show that you didn't take reasonable precautions, that you didn't act reasonably under the circumstances to make sure that what you published was true. And notice what I said, reasonable under the circumstances. So there's not one rule book that you can look to. It's kind of a sliding scale based on the circumstances that you're publishing in and what you're publishing about. Okay? It is very, very important, if you're making an accusation against somebody that is in any way threatening or endangering to their livelihood, that a reasonable journalist gives the person named an opportunity to defend himself. If you don't give a reasonable window of time for the person who's accused of wrongdoing to respond, it's going to be very hard to show that you used reasonable care. But that is going to be a sliding standard based on the severity of the accusation. If it's an accusation about a parking ticket, okay, maybe sending the guy an email 30 minutes before deadline might be enough reasonable care. But certainly if it's an accusation the athletic director embezzles money from the school, that one email seeking a comment half an hour before deadline will not cut it. That's not a reasonable opportunity to respond and defend yourself. So you got to apply judgment and common sense and use the care that is appropriate for the severity of the story. All right, let's stop there. Does anybody have any questions? Yes, please.
Now, what if I'm covering a public figure? Are the rules different?
Well, if you talk to enough people about libel law, you're going to hear something like this. You're going to hear people say, Well, a public figure can't bring a claim for defamation because public figures are famous. And that is a gross oversimplification of the law. It is certainly possible to libel a public figure. People like Barbara Streisand have brought successful libel suits. So it is certainly possible to defame even an internationally famous person, but the constitutional rules are different. What the courts have said is that if you're writing about somebody like that, who's world famous, who has access to the media to defend themselves, that person is going to have a harder time proving their libel case. They're going to have to show not just that you went through a yellow light, but that you blew through a red light. You saw warning signs and red flags that that story was wrong, and you went ahead and you printed it anyway. They're going to have a heightened burden to meet, but it certainly is possible to meet it. And again, don't let that public figure status make you sloppy and casual. Assume, in the context of student journalism, that everyone you're writing about is going to be a private and not a public figure. Certainly, a student, probably a professor, is going to be held to the lower libel standard of a private figure. There are people on your campus, head football coach, head basketball coach, president, probably the vice presidents, who the courts would assign public figure status. They would have a harder time proving a libel case, but don't assume that. Go ahead and exercise the reasonable care that you would use for any private citizen. Any questions? Yes, please.
What if the mistake wasn't my mistake? Say I copied some information out of a police report and the police report was wrong. Say they named the wrong person. Is my story still libelous?
In most states, the law recognizes something that's called the fair report privilege. And under the fair report privilege, as long as you do no more than accurately reflect the contents of a public record that is known to be reliable, then even if it turns out to be wrong, you're not liable for defamation. For example, police officer pulls somebody over and arrests him. He writes in his report that it was Larry Wilson, and it turns out to be Larry Williams. Well, Larry Wilson's attorney may be on the phone with you the next day saying, you've accused my client of a crime he didn't commit. But as long as you did no more, then faithfully copy the name out of the police report. The fair report privilege should protect you against a claim of defamation. Why? Because police records are the kind of records that we normally assume are accurate and reliable. That is a lesson and a practice pointer for all of you who are doing any kind of crime or police reporting of any kind. Get the document. Get the copy of the document to defend yourself so that you can show that your reporting was a fair and accurate and truthful accounting of what was said in the public record. There is another very common issue that is arising more and more and more as people start archiving their publications on the web, and that is this. Chances are you're going to get a phone call like this in your newsroom from somebody who's been named in an old police story, and it's going to go something like this. Hey, 10 years ago, I got arrested for smoking a joint in a dorm. I'm now out there in the job market, and when you Google my name, that story is the first thing that comes up, and I can't get a job. I am demanding that you pull that story from your archives, or I'm going to sue you. What do? Or if you're watching this DVD in class, this might be a good time to shut it off and talk amongst yourselves. For the benefit of everybody else, here's what the law says. What the law says is that if something wasn't defamatory at the time that it was published, it doesn't suddenly become defamatory just because it started to bother me now. So that if that story was truthful and accurate and non-libelous to print 10 years ago, it doesn't suddenly become libelous now. In fact, the statute of limitations in every state to bring a claim for libel or defamation is no longer than 2 years. And so if that story that the person is complaining about is older than 2 years, there is every chance that he has waited too long to complain and that his claim is time barred even if the story was wrong and was libelous at the time. The key here is to remember that there's something under the law called the single publication rule. And the single publication rule says publishing is publishing is publishing is publishing no matter where. So that once that story is published one time in my print edition of the paper, the libel clock starts running. And it doesn't become a new story just because you put it up on the web or archive it unless you rewrite it. So don't get into the business of substantially changing and revising and rewriting the stories that you post on your archives. Put a true and accurate copy of the story as it was written at the time. Now, I want to look at another wrinkle in online publishing and defamation.
The anonymity of online reader comment boards makes people brave. It brings out the nasty impulses that people rarely voice in polite company. When the Daily Reveille, a newspaper at Louisiana State University, wrote about a student who was in trouble with the university after his ex-girlfriend filed a disciplinary complaint, the comment boards lit up. "Watch out," one anonymous reader wrote in, "the next Louisiana serial killer on the loose." The student wasn't amused. He sued the newspaper and its editors, claiming the comment should never have been published, and that the Reveille refused his repeated requests to take it down off the paper's website. A state court judge in Baton Rouge threw out the student's defamation case. Whether or not the remark about being a serial killer was libelous, it didn't matter. A federal law, Section 230 of the Communications Decency Act, protects the operators of a website, like the Daily Reveille's, from being held liable for what readers say on the site. As long as the comment wasn't posted by someone acting on behalf of the newspaper, and as long as the newspaper's staff didn't add anything of substance to the comment, then the only person who could be held liable was the anonymous writer himself, if he could be found. So even though many news organizations will voluntarily take down reader comments they consider libelous, no law requires them to do so. Because reader comments are becoming a common source of legal action, every news organization should have a policy about how to respond if there's a demand for unpublished information, like an IP address that might reveal the identity of an unnamed commenter.
Well, as we said, the Supreme Court has been pretty clear that online publishing enjoys the same status, no more and no less, than publishing on the printed page. But there's one key exception to keep in mind where online publishing is different under federal law. This is something called the Communications Decency Act. Sometimes it's just called CDA, sometimes it's just called Section 230. What Section 230 does is it imposes a different set of standards for content that is posted to your website by unrelated third parties, not by your staff, but by unrelated third parties. The history of the CDA is this. It was passed by Congress as a way to protect internet service providers like AOL, because we recognized that people who were doing nothing more than providing a forum for other people to comment, for other people to communicate, could not possibly police the content of all of that traffic, right? We don't hold the phone company responsible if you make an obscene phone call, and we're not going to hold AOL responsible if you use their pipeline to transmit a defamatory statement. And so the CDA not only protects AOL, but it has been held to protect journalism outlets as well if they offer an outlet for people to publish their comments online. But remember, this only helps you if the comment is authored by an unrelated third party, not by your staff, not by a freelancer, not by somebody you have solicited or paid. What the CDA says is that comment author, the person who comes along on the bulletin board and posts the defamatory statement, is certainly personally liable for the defamation. But you, as the provider of internet service, and that's what you're doing, you're providing internet service, you are not. You are not liable even if that statement is defamatory. Now, ethically, there are publications that have standards about what they will and they won't publish and leave up, and that's a very good conversation for all of you to have when you're an editor at the start of the semester. What is our policy going to be? How are we going to respond to the demand to pull a reader comment? But legally, it is not necessary that you pull a comment even if a person has complained about it as defamatory. Legally, that's not your speech. Does anybody have any questions there? Please, go ahead.
So what about letters or columns that are only in the print edition of our publication?
Well, there are different rules for that. We understand that an internet service provider can't possibly police the content of hundreds and thousands of comments that are flowing through their system. But in print, you're only going to print 5 or 6 letters a day, and the law recognizes that you have enough time to do your due diligence there. So if you publish a libelous statement in a letter to the editor in a print publication, that's your speech. You own that just as much as if you had assigned it to a staff writer and paid somebody to do it. So the lesson from that is check the facts to make sure that the writer isn't making an unsupported factual assertion that could blow up on you. We talked about how the CDA protects against claims of defamation by people who are harmed by comments by outside third parties. The CDA also extends equal protection if that claim is invasive of privacy. If the commenter reveals a private fact that is damaging to the person, then that person's sole remedy is to take legal action against the author of the comment. And by the way, lawyers are getting more aggressive about going to news organizations and trying to subpoena the information about those comment authors. So when you have that discussion at the start of the semester, think about how you'll respond if you get one of those subpoenas. There are some media organizations that are very, very protective of those commenters, and there are some that will more readily turn it over. There's no one right legal answer, but just make sure you have the conversation and make sure you think about it before you have to respond. Well, that is a perfect place for us to transition from defamation law into the law of invasion of privacy. These are closely related concepts, right? Defamation is concerned with, did you publish something about me that is damaging and false? And invasion of privacy is concerned with, did you publish something about me that is damaging and true, right? And that is the major difference between these two bodies of law, is that the truth of what you publish helps you not at all in a claim of invasion of privacy. There are several types of invasion of privacy claims that you could potentially face as a student journalist, and let's just tick them off quickly and then go into more depth. One of them is called publication of private facts, The second is called false light, and the third is called intrusion, and we'll talk about those in sequence. Let's start with publication of private facts. Pretty self-explanatory, right? You publish something about me that's none of anybody's business. You exposed a fact that I hadn't exposed that wasn't already widely known. But remember, it's got to be a fact that's really, really private and really damaging. The kind of fact that would cause people to change their opinion about you, and the kind of fact that you would hesitate to share even with your best friends. You have a fatal disease. You cheat on your spouse, you have a substance abuse problem, you have some kind of very, very bizarre religious or political or sexual practices, the kind of thing that would ruin your reputation, not the fact that you wore your Captain Crunch pajamas to bed until you're 18 years old, okay? It's got to be something truly, truly damaging in a lasting way to your reputation to give rise to a claim for invasion of privacy. Here's why, as a journalist, you're unlikely to have a big legal problem with publication of private facts, because the newsworthiness of the information is a legal defense to this claim. And so, you as a journalist, let's face it, how often are you going to want to publish something about a private individual that's not newsworthy? So the newsworthiness defense will almost always salvage you against this claim. Think about it. If the athletic director gets pulled over in his car and he's got an open bottle of Jack Daniels and his mistress with him, okay, he can't very well come back and complain when you write this story that writing about his mistress is somehow invasive of his privacy. Now, ordinarily, right? Ordinarily, writing about somebody's marital situation might be an invasion of privacy, but this situation has become newsworthy because it resulted in an arrest, it resulted in a traffic stop, it resulted in the creation of a public record. So it has now become newsworthy, and it would not be invasive of privacy to publish that information. And remember that what's newsworthy operates on kind of a sliding scale, right? So that the celebrity of the individual person may make an ordinary, mundane thing newsworthy. If it's Britney Spears, that maybe buying a burrito at 7-Eleven is newsworthy, okay? If it's an ordinary person, not so much. But remember that if the fact emerges as part of an arrest or a traffic stop or police activity, then reporting on it is almost certainly going to be privileged as newsworthy. Here's the other important thing to remember about invasion of privacy. Consent is to invasion of privacy what garlic is to Dracula. It kills it dead, okay? Consent always will defeat a claim for invasion of privacy. So that if a person consents to an interview, and in that on-the-record interview, they reveal a private fact, they cannot come back later and sue you for invasion of privacy for publishing what they voluntarily gave you in an interview that they knew to be on the record, okay? Let's shift gears for just a minute, and let's talk about the second claim, a claim of false light. This is exactly what it sounds like. Not that you've accused me of something I didn't do, but that you've put me in a context that makes it look like I'm doing something that is damaging or harmful to my reputation. This arises from time to time when people get sloppy or lazy about how they use stock images or file photos. That's the #1 risk factor to look out for if you're trying to be careful about false light, is mislabeling a file image, okay? So, what do I mean by that? Let's say you have a legalized drugs rally on your campus, and you don't get a good picture of it, so you just go pull one off of an internet search or you pull one out of a file. And it turns out that the person that you've identified as marching in the legalized drug rally, in fact, was a Boy Scout leader who was marching in the Christmas parade, okay? Well, you've now taken that Boy Scout leader and you've placed him in association with a controversial political view that he may not hold and that may be damaging to his status as a Boy Scout leader, right? That can be false light. So just be extra careful when you're dealing with file art or art you take off the internet to make sure that you faithfully and accurately label it. Now let's talk about intrusion. Okay? The question comes up all the time, where do I have a right to take pictures? Where do I have a right to shoot video? Am I invading somebody's privacy? And people will complain about this without good legal grounds. We actually dealt with a case at the Student Press Law Center where a circus complained because a student journalist was shooting photos of their elephant as the elephant was being washed in a public parking lot. And what they said is, that's a private elephant. That elephant is our property, and you've got no business taking pictures of it without our express written consent. And the answer to that is, of course, if you don't want your elephant photographed, don't wash him in the Walmart parking lot, right? We all know that if you do something, here's the rule, if you do something where you're exposing yourself to public foot traffic, if you do something where you know that you're going to be seen by the copier repairman and the guy who stocks the soda machine and members of the general public, then you have no reasonable expectation of privacy. And if you have no reasonable expectation of privacy, you have no claim for invasion, okay? But people will complain anyway. This is one time where the law and your common sense are actually in perfect alignment, and your common sense will be your guide, okay? We could not possibly have a different legal rule. Suppose I am in the stands at a baseball game. Guy hits a game-winning home run into the stands. My buddy next to me catches the home run ball. Newsworthy moment that ESPN is going to want to televise. Do you mean to tell me that I could tell ESPN, You can't broadcast that game-winning home run because I haven't signed a written consent form to having my image telecast, right? Of course not. We know that's wrong. We know that's wrong. I can't take that event off the record by withholding my consent to be photographed in a stadium that's full of 50,000 people. I'm already in a lot of people's pictures, right? I'm already in a lot of people's pictures and a lot of people's videos without my consent. So common sense tells you it cannot be the case that you need consent to film or photograph somebody doing something in public. There are places where people have a reasonable and legitimate expectation of privacy, and again, your common sense tells you what those are, right? Your bedroom, your hotel room, your doctor's office, or any place you might get medical treatment, a locker room. Frankly, good rule of thumb, any place that you would feel comfortable dropping your pants is a place where you have a reasonable expectation of privacy, right? All those places, certainly. You can't just thrust your camera lens and start shooting pictures without consent. You might be invading privacy. Let's stop there. Does anybody have any questions? Yeah, please go ahead.
So what if we're doing a story on a child and we're filming him? Don't we need the parent's permission to show his face?
It's funny, there is a widespread myth, and it is a myth, that there are different rules for children in public places, and the law doesn't recognize that. The law recognizes that if an 8-year-old is in the ballpark and catches that home run ball, the very same law applies. When you went to the ballpark or your parent took you to the ballpark, you understood that you were doing something in public and you were subject to showing up in a video and showing up in a photograph, and there is no invasion of privacy and no violation of the law in publishing that photograph with or without consent. Now, there is one exception where people, adults and children, do have control over the use of their images, and that's in connection with advertising, right? So that if you want to take a photo of me sitting in the sidewalk cafe, stuffing a piece of pizza in my mouth, go right ahead, but you cannot put that into an ad for Ernie's Pizza and imply a commercial endorsement, imply that I endorse Ernie's Pizza without my signing a model release. The rules are different for commercial endorsements. Now, if you are doing a story where a child is the source and you're implying something that's really private and potentially damaging and embarrassing about that child, let's say you've got a 14-year-old child who's talking about substance abuse, an eating disorder, cutting, suicide attempt, the kind of thing that would obviously be a very private, intimate thing that you'd share only with your family. In that context, it's a good, safe practice to get a signed consent form at least from the child. And if the child is very young, let's say 14 or under, it's probably a good idea to get one from the parent as well. You have to think, again, on a sliding scale here, about the severity of the story that you're doing. A 14-year-old has perfectly valid legal capacity to consent to a story about whether they like Justin Bieber or Miley Cyrus better. They may not have full legal capacity to consent to a story about their suicide attempt. So be circumspect about that, use your common sense, and think about whether a release is necessary to protect yourself. Just by way of wrap-up to this discussion, I want you to remember that lawsuits against the student media are very, very rare, and successful ones are even rarer. The law is, in fact, pretty darn protective of the rights of publishers, and it's even protective of the ability to make an honest mistake, especially in haste, especially in a late-breaking news situation where you may not have every opportunity to do the optimal level of verification. But do not make the mistake of being casual about verification now that online publishing has made it very, very easy to publish. Don't let the casualness of online publishing make you casual about the truth. Using reasonable care is your very, very best libel insurance. And if your gut is telling you that the story is thin, that the story is shaky, that you're not sure about it, then trust your gut, because it's always more important to be right than it is to be first.